Good. I call the Honourable Member Holly Walker. I have to be able to hear you, Ms Walker.
Thank you, Mr Speaker. I'm rather short of breath these days, but I'll attempt to speak loudly. I'm pleased to stand to support the passage of the Inquiries Bill and to begin where my colleague Ruth Dyson, the Honourable Ruth Dyson, has finished, to join her in thanking the Minister for the robust process that has been followed over the last few days, both to address the concerns raised by the Green Party in the committee stages in the second reading of the bill, and also to adopt the supplementary order paper from Trevor Mallard. I agree with her that it has resulted in a better bill. And it's a bill, Mr Speaker, that is long overdue, and indeed we've heard from a number of speakers it's languished at the bottom of the order paper since 2009, and it's now passed rather quickly through its final stages over these last 3 days. So it's also good that despite that haste, those concerns have been taken seriously. Obviously, it's politically expedient for the government to have this in place to inquire into the Fonterra botulism crisis, and it's right and good that the new rules will apply for that inquiry. So it's better late than never, Mr Speaker, that we're passing this legislation. It is a much-needed modernisation and simplification of the rules governing inquiries, and it does update legislation that is over 100 years old, so well past time. Mr Speaker, the bill establishes two types of inquiries, public inquiries and government inquiries. And while both types of inquiries will have the same powers and functions and be governed by the same rules under this legislation, there is a key difference between them, and that's been quite important in the consideration of the bill in the stages over the last few days. Public inquiries, which will include royal commissions, which are perhaps the most well-known form of public inquiry, will be established by the Governor-General, and they will be functionally independent of the government of the day in terms of how they're carried out, much as current commissions of inquiry and royal commissions are held today. Whereas government inquiries will be established by ministers, one or more ministers, and will be driven and led and directed largely by those ministers. So they will be less apolitical than a public inquiry will be. And the key change in this bill is that it extends the same rules and powers and functions to both types of inquiries, and that is the biggest change from the status quo, so that either inquiry can now be established to look into any matter of public significance and will have the same powers and functions and abilities to compel evidence. Now, this is appropriate in our view because there's a clear sense that one of the shortcomings of the current framework is that there's not enough scope to set up different types of inquiries for different situations with the relevant powers. And for example, there's a very big difference between an inquiry into a particular incident or issue that's aiming to get to the bottom of a series of events or perhaps allocate responsibility for something happening. There's a big difference between that and a general inquiry into a matter of public policy, for example, like the Royal Commission on the electoral system. So it's appropriate that we have some flexibility about what kind of structure we can apply to those different types of inquiries. And sometimes both types of inquiries will need the same investigative powers, and sometimes they won't, and that flexibility now exists under this bill. It provides the necessary flexibility to ensure that inquiries function well and have the ability to make concrete findings, and it also ensures that they have the ability to discover relevant information and call witnesses when they need to. And also, crucially, it assumes a high level of public transparency and openness in the conduct of those inquiries, and that is very important, and that has been enhanced by the supplementary order paper in the name of Trevor Mallard, which has been adopted by the government. So we support all of these things. However, Mr Speaker, we did raise some concerns that there may have been some fish hooks, so to speak, in the new rules at the second reading, and we abstained on the vote at that stage for a number of reasons. Now, we were concerned that by granting those quite extensive powers to compel witnesses to appear and disclose information to inquiries, that the bill may have inadvertently impacted on the ability of journalists to protect their sources, or on the ability of MPs to protect their private communications with their constituents. And both of these are important democratic principles which we strongly believe need to be protected. However, thanks to helpful contributions from members in the House, from a close reading of the bill and the Evidence Act to which it is connected, and a helpful response from the Minister's Office, we have been reassured that the protections in place in the bill do afford the relevant protection to confidential and privileged information, and they're sufficient to allay our concerns about those things, because the bill ensures via Clause 28 that the same protections apply to inquiries as they would to civil proceedings, and that includes specific protection to journalists from disclosing their sources under Section 68, and also under Section 69 it includes protection for confidential information, specific relationships and the free flow of information. And on our reading, that would protect MPs' communications with their constituents. Now, the third area of concern we had, Mr Speaker, which we raised at the second reading, relates to a matter of parliamentary privilege. And we asked the hypothetical question, what would have happened if the Henry inquiry into the leak of the Kitteridge report on the GCSB had been held under the new rules proposed by this legislation? Obviously, we've been very concerned, as have others, about the way that Henry inquiry was conducted and the fact that it was able to access email, phone and swipe card records, even though it didn't have the power to compel the disclosure of that evidence. And we felt this constituted a breach of parliamentary privilege and an intrusion from the executive sphere into the legislative sphere, effectively breaching our principle of separation of powers. And we were worried that if powers to compel the disclosure of evidence are extended to government inquiries under this new legislation, a similar situation could arise in future with the legal backing of this bill. Now, we still have that concern, and we think that when the new legislation is in place, it will be more important than ever for the critical distinction between the executive and the legislature to be respected in such cases as that kind of inquiry, and for parliamentary privilege to be upheld and protected. But what it really comes down to is the question of whether or not this particular information in this case was protected by parliamentary privilege. Now, we believe it was, and it would therefore be protected under the new legislation as well. However, we acknowledge that this is a live issue in front of the Privileges Committee at the moment, and ultimately the Privileges Committee will rule on that matter. And indeed, we may see legislation in this House clarifying matters of parliamentary privilege, which would be helpful because that would set out in no uncertain terms what is protected under privilege and what is not. However, Mr Speaker, it's clear to us in the Green Party that such legislation would be the appropriate vehicle to clarify matters of privilege, not the Inquiries Bill. So it's sufficient for us to now to know that parliamentary privilege is protected under this bill, along with all other types of privilege in Clause 28. So for these reasons, Mr Speaker, the Green Party will support the bill. It does modernise and update existing law and provide for a more streamlined and simple process for inquiries in the future. We acknowledge that it probably should have been passed quite a long time ago instead of languishing at the bottom of the order paper, but it's better late than never. And we also hope that these important matters of democratic principle and parliamentary privilege that we have raised during the second reading and committee stages, and indeed today on the third reading, will be taken very seriously both by colleagues across the House, and indeed that seems to have been the case in the way the debate has been conducted, and I thank colleagues for that. And we also hope that they'll be taken very seriously in the conduct of future inquiries under this legislation. Thank you.
I call the Honourable Member Kamaljeet Singh Bakshi. Sat Sri Akal.
Sat Sri Akal, Mr Speaker, and thanks for the opportunity.